Hello, welcome to the channel. We are going to analyze the case DMOCRACIA, the Spanish government's epic trademark blunder. Imagine this. A national government decides to launch its own streetwear clothing line. They hire top-tier influencers to promote it, and the campaign goes absolutely viral on social media. But they forget one tiny detail: to actually register the trademark. And to make matters worse, the very next day, the main opposition party swoops in and files the trademark registration under their own name. Sounds like a plot straight out of a Netflix legal drama, right? Well, that's exactly what just happened in Spain with the brand DMOCRACIA. Welcome back to the channel. Since this was a temporary marketing campaign and the clothes weren't meant for public sale, the bureaucrats in the government offices probably thought, hey, we don't need to waste time registering this with the Spanish Trademark Office, assuming they even thought about it at all. Big mistake. Huge. Because the very next day, on July 9th, the political party VOX ran to the Trademark Office and applied for the brand DMOCRACIA. Cuando te vistes, te posicionas under their own name. Talk about an epic, historic gotcha moment. They literally stole the government's thunder and their brand name right out from under them. Now, this is where things get fascinating for intellectual property and trademark law nerds. Is this even legal? Should the government have registered the trademark before launching? Does the brand belong to VOX now? Will the application be approved? And what can be done next? Are we about to see politicians from opposing parties selling rival hoodies and t-shirts? The internet has been flooded with wild theories and hot takes. That's why, as a channel specializing in intellectual property, backed by a team of experts with over 25 years of experience, we want to bring some clarity and objective analysis to this legal chaos. And hey, full disclosure, we were planning our official channel launch for the end of the month. But this topic is so hot, and there's so much misinformation out there, that we decided to drop this special pre-release video today. Plus, we want to analyze this case to provide concrete solutions and guidance for anyone who might find themselves in a similar situation. Because trust us, it happens way more often than you think. Let's look at the facts. First of all, registering a trademark is completely voluntary, but it is always highly recommended. And it comes down to two main reasons. First reason, the obvious one: to stop your competition from copying you, or worse, registering your name first and legally banning you from using it. This happens all the time in the business world. Partners split up, one secretly registers the trademark, and suddenly he owns the business while the other partner is stuck in a nightmare lawsuit. We see it with famous rock bands, too. Look at La Oreja de Van Gogh in Spain. The lead singers might change, but the brand remains with the group. Sometimes business owners think registering their corporate name is enough, only to watch a competitor steal their commercial brand. Even giants like McDonald's have historic trademark battles, which we can dive into in another video if you guys want. Let me know in the comments. The second reason is to avoid infringing on third-party rights. Registering the mark and doing a thorough trademark search before you launch ensures that the brand you're investing your hard-earned money and time into won't be shut down by someone who already owns the same or a similar name. A third party could sue you for damages, completely sinking your project before it even takes off. If you have great lawyers and a bit of luck, you might fix it, but you're looking at a costly legal battle. As old legal wisdom says, may you have lawsuits and may you win them. Translation: prevention is king. Always register your trademark before showing it to the world. Especially since a basic registration only costs a few €100. Now back to the DMOCRACIA case. The government's excuse was that they didn't register it because they weren't planning to sell anything. It was just a promotional line. They even coined a bizarre new term: the concept of a fictional trademark. Let's clear this up right now. That concept does not exist in trademark law. It's completely made up. The law does not care if your brand is real, fictional, temporary, or a joke. For the Spanish Trademark Office and for intellectual property law globally, a trademark is simply a distinctive sign that meets legal requirements, gets registered or not, and is used or not in the market. Even if DMOCRACIA was just for a promotional merchandise line, it absolutely could, and in our expert opinion should, have been protected. They should have done a solid trademark clearance search before spending a single euro of public funding, and definitely before launching the campaign. And let's be precise here. The government could have protected this brand not just for the merchandise itself, which VOX just applied for under Class 25 for clothing and apparel, but also for the actual advertising and promotional services they were running, which falls under Class 35. Trademarks are registered in relation to specific goods and services. We'll break this down in future videos, but the bottom line is, the government's excuse of a fictional brand holds zero legal weight. Additionally, we are talking about an institutional advertising campaign that is worth millions, over 14 million euros for the full campaign. Therefore, a competent, well-advised government had clear, standard legal avenues to protect that massive investment of taxpayers' money. Because public money doesn't just belong to no one, it's paid for by the sweat and tears of citizens, and it must be managed responsibly. From a purely legal standpoint, the government missed two clear options. Option 1, preventive registration, the gold standard. If you're launching a massive campaign, even a temporary one, you register it. You file it under Class 25 for the merch you're giving away or Class 35 for the advertising. Plus, since under the Spanish and European trademark law, you have a generous 5-year grace period to prove commercial use, the campaign would have been fully covered without even needing to sell a single shirt. Rule of thumb: if you're going to make noise with a new brand name, lock it down first. Option 2, the umbrella strategy. If you don't want a standalone registration, you always display your main registered corporate logo or trademark clearly alongside the temporary campaign slogan. Don't just give away hoodies with a catchy phrase. Put your official government seal or brand logo in the corner. That way, the merchandise is legally protected under your main identity shield. But the Spanish government didn't do either. And now, they have a massive problem. If they want to salvage the brand or continue the campaign without the sword of Damocles hanging over their heads, meaning the threat of VOX legally shutting them down if their application is approved, the government has to act, as we will see. But let's look at VOX's application first. First things first, VOX does not own the trademark yet. They have only applied for it. A lot of Spanish media outlets are reporting this as if the registration is automatic. It isn't. In Spain, trademark law doesn't operate on a simple first-come, first-served automatic deposit system. Once an application is filed, the Trademark Office reviews the formalities. If it passes, the application is published so third parties can object or file oppositions. Only after the opposition window closes does the office review absolute grounds for refusal in a deep merits examination. Right now, VOX is only at step 1, the formalities examination. This means the government still has several legal weapons to block VOX or invalidate the trademark if it gets registered. Let's look at the 4 possible scenarios. Ex officio refusal. The office rejects it on its own. Some Spanish media outlets claim VOX can't trademark the word democracy because it's a common term or misleading. In our expert opinion, this argument is wrong. The word democracia is highly distinctive for clothing and apparel because democracy has nothing to do with fabric or fashion. It's also not inherently misleading. In fact, words like democracy or democracia are already registered for clothing and for other products or services. For example, publications in Spain, Europe, and the US. As you can see on your screen right now, we ran several searches and there are plenty of active examples. So, the office won't reject this automatically. Filing an opposition. The government could file a formal opposition once the application is published, claiming prior rights. Even without a prior registration due to the massive multi-million euro reach of the campaign, they could argue democracia qualifies as an unregistered, well-known, or notorious mark under Article 6 bis of the Paris Convention, which is recognized in the Spanish trademark law. If they can prove the intense public penetration of the campaign, the office might side with them. The third option would be a reclamation lawsuit for recovery of ownership. They could take VOX to court, either now or within 5 years after registration or after the first use of the mark, arguing that the government is the true, legitimate creator and owner of the brand, not VOX, And a fourth option would be the invalidation based on bad faith after the registration of the application. The government could petition the Spanish Trademark Office to declare VOX's trademark null and void, proving that VOX filed the application in bad faith, knowing the brand belonged to a government campaign, solely to boycott it or profit from its virality. This action never expires and can be a powerful defense if VOX ever tries to sue the government to stop the campaign. Additionally, it would even be possible to request the invalidation of the trademark based on the government's prior rights as an unregistered notorious mark under Article 6 bis of the Paris Convention, within a 5-year deadline starting from the date the government becomes aware of the trademark's use. Let me know in the comments if you want us to do a deep dive into how these specific procedures work. So the Spanish government is at a crossroads. They can either keep using their media machine to push this imaginary, fictional brand excuse to avoid admitting they messed up over a few €100, or they can implicitly swallow their pride, try to negotiate a settlement, or gear up for a fierce legal battle in the Trademark Office or the courts following one of the mentioned options. And let's not forget, what about the other pre-existing brands using the word DMOCRACIA, democracy, or other similar words that we showed you earlier? You can see some now on the screen. What's your opinion? Did the Spanish government even check for conflicts before launching their campaign? The debate is officially open. Trying to remain completely impartial here and leaving politics aside, in our opinion, VOX has already won this round. They pulled off a historic political masterstroke, exposing a blatant lack of foresight and agility within the government administration. And they did it by hijacking a multi-million euro public campaign with an application that costs nearly pennies. The moral of the story is crystal clear. If you have a brilliant idea, no matter how temporary or small you think it is, protect it before you show it to the world. Otherwise, someone else will swoop in and wear it better than you. What do you guys think? Let me know your thoughts in the comments below. We love reading your insights and helping out whenever we can. Don't forget to hit that subscribe button, learn the law, and protect your dream. You can also check out our description box for our email if you need specific legal consulting. Stay safe, subscribe, and as we say in law, ignorance of the law is no excuse. Don't let legal ignorance catch you off guard. See you in the next video!